For this next topic, we'll look at arbitration. Arbitration is the preferred method for resolving international legal disputes. Arbitration is a form of alternate dispute resolution. And when we say alternate dispute resolution, we're talking about an alternative to litigation. And it's a technique for resolution of disputes outside of a courtroom setting, but in a manner that mimics a courtroom setting. Now, the parties to a dispute in arbitration will refer it to one or more persons, who's called the arbitrator or the arbitrator panel or arbitrator tribunal. And the parties will agree to be bound by whatever the decision of that arbitrator or panel is. They will be bound by the award. So what's going to happen is that a third party, an independent third party, someone who has no connection with the plaintiff or the defendant, is going to review the evidence in the case, and then they're going to impose a decision. And that decision is going to be legally binding on both sides. And in fact, that arbitration decision can be enforced very easily in a courtroom setting. There is a treaty that provides for the enforcement of arbitration awards, and that treaty makes it relatively easy to enforce an arbitration award in any of the countries that have signed on to the treaty. So arbitration obviously has a number of advantages right off the bat. Now, we have seen in the United States an increasing use of arbitration in recent years. Arbitration was once reserved solely for commercial enterprises, for businesses, but in recent years it's been extended to consumer contracts, things like your cell phone agreement or your credit card agreement or your iTunes agreement, your Xbox agreement. All of those agreements will contain a provision that disputes are going to be resolved by arbitration and not litigation. We've also seen it frequently used in employment matters, including arbitration of disputes that arise out of a public law, something along the lines of Title VII. Title VII claims can be forced into arbitration rather than in federal court. Arbitration will have its advantages and disadvantages as well. So let's discuss those right now. Arbitration advantages. First of all, time saving. There's no doubt that an arbitration can be heard much more quickly than a case can be brought to trial. Arbitration is going to take a little more time than negotiation or mediation, but still going to be heard relatively quickly. It's going to cost less for an arbitrator. Yes, the parties will need attorneys, and yes, the arbitrator is going to cost much more money than a mediator would. However, as compared to litigation, the parties are going to save money. It's going to be much less expensive for the parties to arbitrate a claim than it is to work it out in a courtroom setting. Flexibility is an important advantage. We talked earlier about the inflexibility of litigation because the rules are the rules and they're going to apply to every dispute. Well, in an arbitration, the parties can agree on the rules. They can agree on the rules before the dispute, or they can change their minds and agree on a different set of rules after the dispute arises. But that makes for a very flexible form of dispute resolution. And finally, one of the biggest advantages of arbitration is expertise, meaning your arbitrator is not some random judge that was assigned your case, or your arbitration is not a jury of 12 people who don't know much about the case at all. Instead, in an arbitration, we can hire an expert as our arbitrator, someone who's familiar with the disputes at hand. So if we have a shipping contract, for instance, and we have a dispute involving a shipping contract, we hire shipping arbitrator, someone who's familiar with the law of shipping, who's familiar with damages, who can make a claim, make a damage award based on his knowledge of what the damages should be. So by using an expert, things are much more controlled than they would otherwise be. There are other advantages to arbitration, and this is why it's used so often. Arbitration has the advantages of neutrality, meaning it's an independent third party who's going to hear our dispute, not someone who's involved with the case at all. Confidentiality, it'll be slightly more public than a negotiation or mediation. However, we can still limit outside knowledge of the facts at hand. The parties can be sworn to secrecy. The arbitrator will have a confidentiality agreement, and all of the documents and evidence that's entered in the case can be sealed afterwards or destroyed or however we want to handle it. So confidentiality is a strong advantage of arbitration. Enforceability, and we'll talk more about the enforceability of arbitration awards, but I mentioned it early on that it's very easy to arbitrate, to enforce an arbitration award. There's a lot of institutional help available, meaning there are arbitration companies that only do arbitrations. Their job, their business is providing arbitrators and an arbitration infrastructure, and therefore there's a great deal of institutional help. Again, we don't have to recreate the wheel, nor do we need to hire an attorney to explain to our business how the arbitration is going to work. We can go to the arbitration business itself. Arbitration helps to mitigate hostilities because there's going to be a third party that's ultimately making the decision. It's not going to be a question of mediation where the parties are going to try to work out and maybe get locked into a belief as with negotiation. Instead, because in an arbitration, each side tells its side of the story, and then an award is made, and therefore less hostility between the plaintiff and the defendant. Now, there are disadvantages to arbitration as well, and one of which is the fact that if the parties don't have bargaining equality, if there's not parity between the parties when entering into a contract that provides for arbitration, then it's possible for a set of procedures to be put in place that would be unfair to one or both of the parties. There's other advantages. It can be difficult to find out what this dispute is worth because arbitration awards are confidential. So as more disputes are heard in an arbitration setting, it's difficult to know how most disputes can turn out. It's also difficult to gauge the potential upside or downside, again, because you're working with an arbitrator that you are not familiar with and you are unable to look at this particular arbitrator's previous awards. It can be hard for you as a business to judge what's the upside and what's the downside. Of course, the biggest disadvantage of arbitration is probably the fact that there's no appeal. It's impossible to appeal an arbitration. It is binding, meaning whatever the arbitrator says, that is going to be the result. I cannot take that arbitration award to a court and argue that the arbitrator was not fair. The court will refuse to hear that case. There is in the law a great weight of sentiment in favor of enforcing arbitration awards, and therefore in a court you are unlikely to find any help when you go to assert that the arbitration was unfair or that the arbitration award was unreasonable. Finally, the major disadvantage of arbitration, and I've kind of alluded to that, is it prevents the free flow of information and the free flow of expertise because of its confidential nature. If these disputes were being heard in courtrooms, then everyone would know what was going on in the dispute. Everyone would be familiar with the value of the dispute, and therefore both information and expertise would flow more easily. For this next topic, let's look at some of the things that a business should consider when drafting an arbitration agreement. Remember, an arbitration agreement, one of the key advantages is it places control into the hands of the litigants. The parties can decide between themselves on the rules of the arbitration. They don't have to rely on artificial civil procedural rules provided by a court. Instead, the parties can work it out themselves. So in an arbitration agreement, what are the decisions that have to be made when creating the agreement? There's a number of items, and I've listed a number of them in your lecture notes. And you may well think of some on your own, but this is something that will probably appear on exam at some point. Well, first of all, we talk about the scope of the clause. Should it be a broad clause, meaning all disputes should be resolved in arbitration? Or we can make it a narrow clause in which only certain disputes are subject to arbitration while reserving litigation for other disputes. We have to talk about the location of the arbitration. Where will the arbitration take place? And what language will the arbitration take place in? Again, in an international dispute, there may be multiple languages at issue, and you cannot simply assume that the language will be your particular language. We can put that into our arbitration agreement. Notice provisions, we can provide for the time periods that are required to give notice of any dispute or any allegations regarding the dispute. Those can be placed within the agreement. We want to talk about the law, the choice of substantive law that will govern the dispute. Again, in an international context, you're going to have law from one side or the other, and it's important to choose the law that's going to apply to your particular dispute. We've mentioned discovery several times. We need rules for how do we discover evidence from the other party, and what evidence will be permitted to be introduced. In a lawsuit, the rules of evidence will govern the evidence that the fact finder can hear or not hear. In an arbitration, unless there's an agreement reached beforehand, the arbitrator is going to be entitled to hear everything related to that lawsuit. Who are the arbitrators going to be? That's something else that we can reach into, that we can decide beforehand and put into our arbitration agreement. We can choose particular individuals, or we can choose particular arbitration companies, but we can work it out in advance. We can work out the procedures that will be followed, what sort of procedures will govern our arbitration resolution. We can place confidentiality measures into effect. What sort of things do we want to keep confidential? How much confidential information is going to be retained, meaning should things be destroyed or not, and also penalties for if a party breaches the confidentiality agreement, the confidentiality aspect of the arbitration. We can provide for penalties after the fact. We can provide for claim consolidation, meaning do all claims have to be heard in an arbitration or only specific claims? Does a party have to bring a counterclaim within the arbitration, or can they wait on that and file a second arbitration to cover that claim, that counterclaim? Things to do with money, currency, what is the arbitration award going to be made in? What is it going to be? What will the eventual monetary unit going to be used? It's going to be the dollar, the euro, something else, we don't know. Cost, or will each side have to pay their own cost, or can cost be imposed on the loser in the arbitration? Is cost something that an arbitrator can decide? Or do you want to have a provision where costs are going to be split one way or the other? And finally, finality. Now, there's not a lot we can say about finality because there is going to be this fact that courts won't hear a final arbitration award, but we could theoretically put in a provision that provided for appeal to another arbitration panel. So that's something that we could include in our arbitration agreement. Finally, we want to look at a couple of other matters related to arbitration. First of all, there are laws that govern the arbitration process. In the United States, arbitration is governed by what's called the Federal Arbitration Act. The Federal Arbitration Act was passed in 1925, and what it was designed to do was to provide legitimacy to arbitration awards, to ensure that courts respected arbitration awards. Courts had long been hostile to arbitration. Some saw it as essentially taking jobs away from the court system. So looking upon arbitration as a minor league court system, and so there was a great deal of hostility. Well, in the Federal Arbitration Act, there was established a federal public policy in favor of arbitration. And what the Federal Arbitration Act said was if that two parties had arbitrated an agreement, then a court was required to enforce that agreement, and there were only certain very few limited exceptions to enforcement of that agreement. For international arbitration, there is a United Nations Convention. There is a model law, what's called a model law on international commercial arbitration, and this model law will govern how arbitrations are conducted in the international context. Finally, as I mentioned before, it's easier to enforce an arbitration award than it is to enforce a court judgment. Under the New York Convention, a treaty signed in 1958, an award issued in a state that has entered into this treaty can be freely enforced in any other state that has agreed to the treaty. There are only certain very limited defenses available. So under this New York Convention, it becomes very easy for a party, a winner in an arbitration panel or an arbitration proceeding, to take that arbitration award to another court and have that court enforce the award. Virtually every significant commercial country in the world is a party to the convention. Now, this differs from a court judgment. Under a court judgment, there's very limited recognition of judgments from country to country, and those judgments remain susceptible to claims of unfairness, unfair procedures. So an arbitration award is much easier to enforce than a court judgment. That's it for arbitration. We'll take up next time.